question that often comes up is, how do I sue my creditors back in bankruptcy? It comes about that many times the creditor has violated the stay or discharge, or there's been a problem with him violating the Fair Debt Collection Practices Act, or the violation of a Fair Credit Reporting Act comes about in bankruptcy court. These lawsuits can be filed in bankruptcy court, and you can actually sue your creditors back. It may be that you make enough money off the lawsuit that it actually pays for your bankruptcy. What happens when you file a bankruptcy is that a temporary court order goes into effect called a stay. This stay ensures that creditors do not attempt to collect the debt while they're in bankruptcy. When the judge and the trustee are trying to run and operate your bankruptcy, they don't want the creditors to come in and interfere with what they're doing. So the very strongest powers that they have to correct a creditor who attempts to collect a debt while you're in the bankruptcy is the powers that allow them to bring a creditor in for contempt of the stay. It interferes with how they're trying to make sure that all creditors get an equal share of any assets. It makes sure that they are not being interfered with in administration of your particular case. At the end of the case, there is a permanent court order called a discharge that goes into effect. When they are punishing a creditor for violating the discharge and for attempting to collect the debt after the case, the powers that they use and the penalties that they assess are going to be a little bit less for violating the discharge than it is for violating the stay. What happens quite often is that you'll get a creditor who isn't afraid of violating the stay. He's not afraid of being sued because he doesn't have any assets. Or you may have a payday loan company that's operating in another country. And because it's difficult to sue that creditor who only exists in another country and only can collect by getting the numbers of your bank account, it is difficult for the judge to issue an order, and it's difficult for your attorney to go after that creditor. Quite often, the best you can do is just simply block that creditor. But you can, if the creditor does attempt to collect during the stay, you can record what the creditor was done. You keep accurate records, and you come into court and you show the court that the stay has been violated or the discharge has been violated. Another important federal act that you can look at as far as punishing the creditor for improper conduct is the Fair Debt Collection Practices Act. The Fair Debt Collection Practices Act only ends up correcting a creditor when there is a debt collector attempting to collect a consumer debt. If it happens to be a debt for your business that you're operating, the Fair Debt Collection Practices Act does not apply. Also, if it is a creditor who's collecting his own debt, the Fair Debt Collection Practices Act does not apply. You have to find a debt collector who's collecting for a debt that does not belong to them. And recently, many debt collectors have been buying these debts, and therefore, since they bought the debt and they're collecting their own debt, the Fair Debt Collection Practices Act does not apply to them. There are at least 30 different specifically enumerated things that the debt collector cannot do, and they're listed on our website, but they're listed in the act. One of them is you're not supposed to file a lawsuit in a state or a jurisdiction that the consumer does not reside in. Another one is that you're not supposed to file a lawsuit where the statute of limitations has run. Very recently, we ended up suing in a case where there was a foreclosure, and the creditor had not collected a single payment within 7 years, and the statute of limitations had run. Actually, the creditor had waited well over 14 years before he attempted to collect the debt. In our state, there is a statute of limitations that is 15 years long, 10 years long, and 7 years long, depending upon what kind of debt and when the debt was made. We not only sued and wiped out the second mortgage, but we also ended up suing the attorney who attempted to collect on that debt and that filed the lawsuit. And it's an entirely different type of case when you are suing the debt collector and the debt collector has no chance of collecting the debt. It changes things from you attempting to see what you can get your payments down to how much am I going to collect from this debt collector. The Fair Credit Reporting Act during a bankruptcy is also important. What you will find is that at the end of the bankruptcy, all of your debts now are no longer enforceable. You no longer owe any of these debts. Under the Fair Credit Reporting Act, most creditors, if they properly report the debt, will end up saying that the account is closed, not that you're 6 months behind or 9 months behind or that they never collected the debt. And the effect on your credit report is entirely different when the account is closed than if the account is in default. Quite often, people who file a bankruptcy, their credit actually goes up. You have to document all of these things, whether you're suing the collector for contempt of the stay or discharge, whether you're suing to collect under the Fair Debt Collection Reporting Act, or whether you're suing under the Fair Credit Reporting Act. You have to document how it affected you, what the creditor did, how we attempted several times to not have to go to court in order to stop his adverse behavior. And the more you document it, the better the results will be from that lawsuit that you file. Quite often it's filed as an adversary proceeding, but in some jurisdictions, you may be able to get all you need by filing a simple motion and obtaining a restraining order and some small amount of damages. If you happen to have problems like this, and you shouldn't have problems like this in your bankruptcy, because your attorney should have a reputation for enforcing the stay and the discharge order and the other laws that protect you as a consumer. If you're having problems like this, be sure to call our office. We're happy to talk with you. We file bankruptcy, we handle foreclosure and student loan cases here in the state of Kentucky. Thank you.